paso ya a presentarles los ponentes de esta tarde. Nuestra idea un poco al organizar este seminario era que pudiéramos abordar las cuestiones que afectan a la gestión internacional del agua y a la cooperación internacional desde diferentes perspectivas. Una perspectiva, digamos, más, si se quiere, de instrumentos y más formal en la primera sesión, desde la perspectiva también del derecho internacional. Otra perspectiva más desde el punto de vista de la gobernabilidad de estos recursos, de este recurso. Otra perspectiva más centrada en el ámbito de la Unión Europea, que es la que tendremos el próximo martes, e igualmente otra perspectiva también más centrada en lo que sería propiamente las cuestiones más vinculadas con la aplicación en España, los problemas que se plantean con algún caso de estudios, es lo que tendremos también oportunidad de ver el próximo jueves. Bien, estamos en esta sesión hoy relativa ya más a la gobernanza internacional y a los distintos instrumentos de gobernanza internacional y a la interacción que se produce entre el régimen internacional en materia de aguas y otros instrumentos internacionales que veremos, obviamente, tienen una incidencia clarísima en la gestión de este recurso, como es en el caso del cambio climático. Perdón. Para ello, vamos a contar esta tarde con dos excelentes ponentes que van a ilustrarnos sobre estas cuestiones, a los cuales paso ya a presentar sin mayor dilación. La primera intervención relativa a la gobernanza digamos, del agua a nivel europeo, pero entendido en el contexto más general de este término, correrá a cargo de la profesora Ragma Bentigú. La profesora Bentigú, ella actualmente se encuentra en la Universidad de Barcelona realizando una estancia, un periodo de investigación como postdoc, como investigadora invitada en nuestra universidad, y está colaborando también con los trabajos de la Càtedra de Monnet. La profesora Bentigú, ella ha estado impartiendo clases y haciendo investigación en la Universidad de Neuchâtel desde el 2013 en Suiza, donde ha impartido cursos magistrales en la Alta Escuela de Gestión de Neuchâtel, ha sido también profesora de Derecho Europeo e igualmente también ha realizado otras actividades vinculadas con la docencia. Desde la perspectiva de la investigación y sobre todo pues, a partir del trabajo de tesis doctoral sobre el derecho a un medio ambiente sano en derecho europeo, sus líneas de investigación se han orientado pues, claramente hacia estos temas, ¿no? Principalmente el derecho europeo y la protección del medio ambiente o el derecho a un medio ambiente sano, desde qué perspectivas se puede examinar o con qué, digamos, en qué contextos o en qué marcos institucionales se ha reconocido un tal derecho, especialmente en el marco del Consejo de Europa y en el marco de la Unión Europea. Ha trabajado también sobre temas de responsabilidad medioambiental y después también ha trabajado en una línea que yo también me parece muy interesante, como es la del respeto de los derechos humanos en los contratos de explotación de recursos naturales. La profesora Bentigú evidentemente ha participado en diversos proyectos y tiene también varias publicaciones, tanto en obras colectivas, sobre todo en el contexto francés. Tiene además también diversos artículos de revistas y en particular está coordinando también un número específico de la Revue Juridique de l'Environnement, que es una de las revistas clásicas en derecho ambiental, es de hecho la revista de la Asociación Francesa de Derecho Ambiental, iniciada por el profesor Kiss. Es uno de, ya digo, también de los profesores que cualquier persona que se dedique al derecho ambiental debe leer necesariamente, pues ella está también coordinando un número sobre un tema también sumamente interesante, el dinamismo del derecho, el activismo de los jueces. En este sentido, para nosotros, y porque además también, pues actualmente, ya digo, es profesora invitada en la Universidad de Barcelona como investigadora postdoc, es un placer que pueda hoy compartir esta sesión con nosotros. Y ella hará, ya digo, la sesión relativa a la gobernanza de las aguas a nivel europeo. Nuestro segundo ponente es más joven, como podrán ver también en su pantalla. Nuestro segundo ponente es especialista, de hecho, y está actualmente terminando ya en el último año de su tesis doctoral en materia de régimen jurídico y responsabilidades jurídicas en el contexto del convenio marco de cambio climático, sus órganos y también de los Estados miembros en relación a un tema esencial, un tema que nos parecía además que era muy interesante de poder incorporar en este seminario, como es toda la cuestión de los instrumentos de financiación y de gestión de lo que es propiamente las acciones de adaptación en materia de cambio climático y particularmente en su estudio se centra también en el caso de los países en desarrollo. En este sentido, sí que quisiera resaltar que el profesor Gonzalo Larrea está actualmente ya, y de hecho ya en la fase final de su tesis doctoral, pero que ha estado trabajando y ha estado también impartiendo a clases en uno de los centros también de mayor reconocimiento o con mayor prestigio en materia de derecho europeo, como es el Instituto Europeo de Florencia. Actualmente él se encuentra también en Barcelona, justamente para finalizar algunos aspectos de ese trabajo doctoral, con una de las ayudas del Ministerio del Programa Salvador de Madariaga, una de las becas para investigadores más preciadas en este país y también, tengo que decir, más competitivas en lo que es el soporte que se da desde el Ministerio a los investigadores. Además, el profesor Gonzalo Larrea es también senior editor del European Journal of Legal Studies, una revista también de absoluta referencia en nuestro ámbito, y ha sido también coordinador del Environmental Law Working Group en el Instituto Europeo de Florencia, o en el European University Institute. Aparte de eso, él también ha estado impartiendo cursos y conferencias en diversas instituciones, entre las cuales pues, quisiera destacar especialmente el King College de Londres. Bien, el profesor Larrea hoy también nos presentará este aspecto tan relevante y tan importante desde la perspectiva del derecho internacional de la interacción entre distintos instrumentos, entre distintos ámbitos de intervención del derecho internacional con el foco en particular en el caso del cambio climático, la financiación y las medidas de adaptación. Muchísimas gracias a los dos por estar hoy aquí con nosotros esta tarde para participar en este seminario y dicho eso no quiero extender más y daríamos ya la voz a la doctora Bentirú para que haga su presentación. Muchas gracias, Rama, cuando quieras.
Thank you, Mar. First of all, thank you for this beautiful introduction for the seminar, and I would like to express first my thanks to Professor Campins for her invitation to intervene today in the seminar on international cooperation on transboundary water. I would have certainly like to speak directly with you, to exchange with students, professors of the UBI, but I will try in those circumstances of COVID to try my best to ensure that the information can reach you as clearly as possible. Today, I'm going to focus on transboundary water governance, or more broadly speaking, water governance in general. I'm going to share the presentation. Do you have, please, all the presentation on the screen?
Yes.
Yes.
Yes, Rama, may I ask you just, I guess that there are some noises from the papers and something like that, just to be...
Okay. Okay. Yeah. So today I'm going to speak about the transboundary water governance, most broadly water governance in general. The purpose is not actually to introduce you to a course on the legal framework of international water cooperation. I think that on this matter, Professor Campins is the most competent to speak to you about integrated management of transboundary water. Objective of this presentation is to share with you some observations on the concept of water governance, on its meanings, its actors, its principles, its challenges, and why not the current problems it faces. So I will structure my presentation in 3-4 points to answer some questions. The first point, the relevance of the issue of water governance. Why is it so essential today to talk about water governance? Second point, what is the definition we should give to water governance? Have institutions or stakeholders or doctrine already tried to find a definition for this concept? Third, who are the actors? Who are the stakeholders involved in the sphere of water governance? And what is the nature of this engagement? Is it political action, administrative action, normative actions? And finally, we are going to discuss a little bit challenges of water governance. First, I think that it is important to note that water governance has held an important place in the works of French and Anglo-Saxon doctrine. It is a subject that has interested not only legal doctrine, but also experts in the natural and environmental sciences. This can only reflect this multi or interdisciplinary character or aspect of the issue of governance, which calls for several profiles in the academic world. And here, as we can see in this slide, we have few examples of works on water governance. This first book, Governance of Water, Institutional Alternatives and Political Economy. And this book is so important because it makes the link between economy, environmental protection, integrated management of water resources, and the instrument to face the challenges of water governance. Also, we have another research, which is water governance in the face of global change, linked a little bit with presentation of Gonzalo. From Understanding to Transformation, it is a book edited by Springer, and the author tried to explain the link between climate changes, environmental protection, water governance, and human rights. Another research also in French Gouvernance de l'eau, un mouvement de réforme perpétuelle. And this book is important. Why? Because it tries to make a relationship between sociology, environmental, and how to solve problems related to water governance. Also, another book, Water Governance, Theorizing Politics, and I give also as an example this book, which is my preferred, edited recently, I think in July or August 2020, concerning water politics, governance, justice, and the right to water. And this study is really so important because it links between the importance to protect, to guarantee human rights, especially right to water, and how to improve water governance in relation with right to water. So here, as we can see in the slide before, water governance has a predominant place in the academic writings of the doctrine. Question: why do we need water governance? Or perhaps the correct question: why do we need good governance? Water governance does exist, but it is probably not as good as it should be. We need water governance for many reasons related to water needs and future water demand in the coming years. As several interlocutors say about governance, especially OECD in 2011, water crises are often primarily governance crises. First reason why we need good water governance is scarcity of water. Water demand will increase 55% by 2050 due to growing demand from manufacturing, growing demand from thermal electricity generation, and domestic use. Managing and securing access to water for all is not only a question of money. It is a question also of matter of good governance. For example, in Mediterranean countries, particularly in arid and semi-arid countries, current practices in the management of water resources have created serious problems in terms of ensuring that future human, economic, and environmental water needs are met. It is important here to know concerning the scarcity of water that scarcity of water, whether absolute or induced, is not, however, the only fundamental reason for improving the effectiveness of water governance. We have also pollution. Pollution also contributes to scarcity and the challenge of meeting demand for good quality water. We need good water governance also because of the lack of accountability and the transparency. The UNDP in 2007 has underlined that corruption remains one of the least addressed challenges in relation to water governance and water service delivery. Corruption nowadays is a symptom of governance deficiencies in both the private and public spheres. In many countries, enforcement of legislation is weak and judicial systems are inadequate. In some countries, and especially poor countries, personal economic gain is more attractive than concern for the well-being of citizens. And in the well-being find good water governance, and in good water governance, of course, we find right to water. We need also good water governance because we need to make a reform for this water sector via the instrument of decentralization. Many countries are currently moving away from these conventional or traditional forms of water governance, which usually have been dominated before by a top-down supply-driven approach towards bottom-up demand-driven approach, which combine experiences, knowledge, and understanding of various local groups and people. Also, good water governance because we need to improve water rights. Ownership or the right to use a water resource or water supply and infrastructures means power and means control. It was underlined by UNDP in 2007. The various roles and responsibilities, such as those encapsulated in legislation on water rights and ownership, have a complex relationship with water governance. How property rights are defined, who benefits from these rights, and how they are enforced are all central issues that often require clarification as patterns of supply and demand change. Finally, the water governance, good water governance needs also to improve the question of gender. Current writing on governance and particularly water governance tends to be gender blind. It is clear that effective, efficient, and equitable water resources management is only achieved when both women and men are involved in integrated water resource management. This was underlined by UNDP in 2006 and in its report in 2007. Gender mainstreaming is the process of assessing the implications for women and men of any planned actions, including legislation, policies, and programs in all areas at all levels. The second point that we will discuss today is what is the meaning of water governance? And to answer the question, we need to know what is the meaning of governance. There is no single definition of governance. There are really different approaches in this field. United Nations Development Programme 2001 said that governance is the exercise of economic, political, and administrative authority to manage a country's affairs at all levels. It comprises the mechanisms, processes, and institutions through which citizens and groups articulate their interests, exercise their legal rights, meet their obligations, and mediate their differences. This is the definition which was given by UNDP in 2001. Some academics or some authors consider governance or may see governance as essentially preoccupied with questions of financial accountability and administrative efficiency. Others may focus on broader political concerns related to democracy, related to human rights, and related to the process of participation public in the decision. There are also those who look at governance with a focus on this match and mismatch between the political administrative system and the ecological system, or in terms of operation and management of services. If we try to apply this definition of governance, water governance, the famous definition given to water governance is the definition given by OECD in 2015. Water governance is a set of rules, practices, and processes through which decisions for the management of water resources and services are taken and implemented, and decision makers are held accountable. We have also another definition of water governance developed by Global Water Partnership, which is an important stakeholder in this field of water governance. Water governance refers to the range of political, social, economic, and administrative systems that are in place to develop and manage water resources and the delivery of water services at different levels of society. So here we have this approach of multi-level water governance. Some academics give another definition of water governance. Governance covers the manner in which allocative and regulatory politics are exercised in the management of resources, natural, economic, social, and broadly embraces the formal and informal institutions by which authority is exercised. And at this point, the new term of discussing this combination between formal and informal institutions is distributed governance. Today, we talk about distributed water governance. I think that there is an important point when we talk about water governance is to distinguish between water governance and integrated water management or integrated water resource management. Why? Because I think that water governance is a concept which is large and more complete than integrated water resource management. And of course, we can discuss after about this concept of integrated water resource management that Professor Campins explained in her presentation this last Monday. I think that, and this is my opinion, that integrated water management does not mean really water management, because integrated water resource is one challenge among others in water. So in water governance, we find integrated water resource, but also we find many other challenges. The famous definition given to integrated water management governance water partnership in 2000, integrated water management is a process which promotes coordinated development, management of water, land, and related resources in order to maximize the resultant economic and social welfare in an equitable manner without compromising the sustainability of vital ecosystems. And according to this definition of integrated water resource management and definition of water governance, I think that water governance is a concept which is more completely than integrated water governance. Because with water governance here, we have 4 dimensions. We have social dimensions, economic dimensions, political dimensions, and environmental dimensions. And to succeed today, good policy in water governance, we need the complementarity between those 4 dimensions. Social dimensions means equitable use, equitable distribution of water resources and services among various social and economic groups and its effect on society. Why? Because nowadays, apart from being inequitable distributed in time and space, water resources and services are also inequitable distributed among various socio-economic groups, both rural and urban settlements. The second dimension of water governance is economic dimension, efficient use. Efficiency in water allocation and use, and the role of water in overall economic growth. Effective poverty reduction and economic growth depend highly on water and other natural resources. The governance structures exert a powerful effect on what they call per capita incomes in many countries. Third dimension is political dimension. And here we talk about decision, we talk about power, we talk about legislations and normative weight. Equal rights and opportunities for water stakeholders to take part in decision-making process, a more effective involvement of commonly marginalized citizens such as indigenous people. The dimension of indigenous people is really so important in the political decision today when we talk about water governance. The fourth dimension, environmental dimension. Sustainable use of water and related ecosystem services. The sufficient flow of water of appropriate quality is critical to maintaining ecosystem functions and services that build upon them. The problem that, unfortunately, water quality is declining in many regions due to inefficient safeguards in the way it's used by intensive agriculture and in large urban and industrial areas. The third point that we are going to expose here, actors in water governance. Organization for Economic Cooperation and Development. OECD is the most famous actor, European level, in this field of water governance. I guess that you know what the OECD, Organization for Economic Cooperation and Development, is an intergovernmental economic organization now with 37 members countries, founded in 1961 to stimulate economic progress, and it's a forum of countries describing themselves as committed to democracy and market economy, providing a platform to compare policy experiences, seek answers to common problems, identify good practices, coordinate domestic and international policies of its member. And general OECD members high-income economies with a very high human development index. And when we speak about the role of OECD in the field of water governance, it is important to deal with water governance initiative. OECD Water Governance Initiative was created on 27-28 March 2013 as an international multi-stakeholder network of 130 members from public, from private and non-for-profit sectors, gathering twice a year to share best knowledge and experience on water reforms, on projects and policy. This water governance initiative has several objectives. Provide a multi-stakeholder technical platform. Why? To share knowledge, to share experience and best practices on water governance across levels of government. Also, water governance initiatives advise governments in taking the needed steps for effective water reforms through peer-to-peer dialogue and stakeholders' engagement across public, private, and non-profit sectors. Also, water governance initiatives provide a consultation mechanism to raise the profile of governance in the global water agenda, support the implementation of the OECD principles on water governance. After that, we are going to see which are those principles of water governance in interested member and non-member countries. Foster continuities and continuity on governance discussions at global level between two World Water Forums by leading governance thematic sessions and events. The composition, here we have in this slide, composition of the water governance initiative until 2021. Water governance initiative members gather in a policy forum twice a year and contribute to the working groups activities at and in between meetings. As we can see here in the slide, it is led by a steering committee of partner institutions providing strategic orientations and operational support. You can find here, for example, in the steering committee of the Water Governance Initiative, ASTII, the Association Scientifique et Technique pour l'eau et l'environnement. We have also Spanish Association of Water Supply and Sanitation and other stakeholders like the Stockholm International Water Institute and International Office for Water. Water Governance Initiative achievements are 2, co-production of the OECD principles on water governance and the implementation of the OECD principles on water governance. And OECD principles on water governance set standards for more effective, efficient, and inclusive design and implementation of water policies and encourage governments to put them into action. Those 12 principles of water governance were approved by OECD Regional Development Policy Committee on 11 May 2015 and endorsed by all OECD ministers at the Ministerial Council meeting for June 2015. They were developed in a bottom-up and multi-stakeholder fashion through the OECD Water Governance Initiative. To date, principles have been endorsed by 170 stakeholder groups or governments, Global Coalition for Good Water Governance, including 35 OECD member countries, 7 non-member countries, and 140 stakeholder groups. As we can see in this slide, we have 3 phases or 3 major points of water governance developed by OECD: effectiveness, efficiency, trust, and engagement. Effectiveness related to the contribution of governance to define clear sustainable water policy goals and targets at all levels of government to implement those policy goals and to meet expected targets. Efficiency, the second phase of water governance, relates to the contribution of governance to maximize the benefits of sustainable water management and welfare at the least cost to society. Finally, trust and engagement, third phase, relate to the contribution of governance to building public confidence and ensuring inclusiveness of stakeholders through democratic legitimacy and fairness for society at large. And as you can see in the slides, every point, major point of water governance is related to a manner or to another principle. In the effectiveness, you see in this principle we have capacity, the policy coherence. Policy coherence, it means that, for example, the environmental policy, water policy, human rights policy have to work in the same way to improve the effectiveness of water governance. For example, also trust and engagement. Here we have stakeholder engagement, integrity and transparency, which is a goal very difficult to fulfill because of the corruption in many countries. Monitoring also and evaluation, and finally in the point of efficiency we find the data information, financing, innovative governance and regulatory frameworks. Those principles of water governance are realized in multi-level governance framework. The OECD established like a map concerning multi-level governance gaps. And the logic of this map or the logic of this framework is mind the gaps, bridge the gaps. Means since 2010, the OECD has provided evidence on the main governance gaps hindering water policy design and implementation, and suggested a set of policy responses and good practices for overcoming them. The OECD multi-level governance framework, Mind the Gap, Bridge the Gaps, was developed as an analytical framework and tool for policymakers to identify and bridge governance challenges that affect, to a greater or lesser extent, all countries, regardless of their institutional setting, water availability, or degree of decentralization. This multi-level governance framework gives what the OECD calls the water governance cycle, or the water quality cycle. And if you want, we can after exchange discuss a little bit this water policy cycles. Other actors important in this field of water governance, we have Global Water Partnership, Stockholm International Water Institute, SCW, and Water Governance Facility, for example, Water Governance Facility supports low and middle income countries in their water reform by policy and technical advices and supports. Here, Stockholm International Water Institute now is focusing on a range of research and development topics within and around water that support decision makers around the world. This institute organized the World Water Week, for example, the Stockholm Water Symposium. It organized also the Stockholm Water Prize and Stockholm Junior Prizes. Challenges of water governance. First, economic, political, and environmental change. And here I refer to the presentation of Gonzalo concerning the climate change in this field of water governance. Second, stakeholder participation is also another challenge of water governance. Pro-poor governance, and actually I discussed during this stage this point because it is so important to improve pro-poor governance today. Integrated water resource management, democracy, democratization of water management, the role of improve, especially the role of experts. Why? Because stakeholder engagement model means that instead the role of water experts becomes the supporting role of helping the stakeholders to discover what are the implications of different options and the aid them in inventing new options. So I hope that the presentation was interesting, and of course I will be glad to listen to your questions and to discuss with you other points which are not very developed during this presentation, especially challenges of water governance. Thank you for all.
Thank you very much, Professor Bentil. I'm gonna stop sharing your presentation. Yes, thank you very much. I think that was a very, very interesting global picture about all these different elements concerning governance, from the interdisciplinarity, which really it's I think clear, in particular in this, probably in all of them, but in particular in this specific sector or in this specific resource. Then also there's different elements of, yeah, you are right, governance, it's different from good governance. And one probably is good governance and not the governance itself. But I think it's interesting to see how all these principles are finally, or all these dimensions of governance are translated into principles in the OECD. I have a question that I will put that in the debate area. So I'm sure that there will be other questions concerning the challenge and all different issues. So thank you very much also for just keeping the time. That was nice. So let's go now with the second presentation from Professor Larrea. You have the floor, so when you want.
Thank you very much, Mar, for also the introduction before, and especially for inviting me to this very interesting conference. I'm so happy to be here and so excited to be talking about water scarcity and water governance. And I don't usually deal these things directly because I'm rather an expert, or I rather focus on climate change. But unfortunately, there are more and more impacts of climate change on water governance in general, on access to water in particular. And so I've been increasingly interested in this area. And I would like to share with you how climate change is affecting water, access to water in developing countries. So against this backdrop, I will first share the presentation with you guys. Let me see. Can you see it right now? No. All right. Wait a second. Vale. There you are.
Yes, yes.
Okay.
Thank you.
So against this backdrop, I will talk about the legal responsibilities of states to cooperate with developing countries that, as I say, are struggling increasingly more to access to water. This cooperation with a focus on climate finance. So I will look at the responsibilities to deliver climate finance to developing countries in order for developing countries to adapt to climate change impacts and ensure access to water to citizens, or generally to be able to manage their water systems that are increasingly affected, as I said, by climate change impacts. In keeping with this, I will also present the international bodies that are dealing with this cooperation in the form of delivery of climate finance to developing countries. These will basically regard to the financial instruments of the United Nations that are basically operationalizing the obligations that I will talk about first. So I will divide this presentation into 4 points. The first one will be on the problem being the relationship between climate change and water scarcity. I will very briefly present it because I will be referring to natural science reports, and I'll be referring to the institutions that have emitted these reports. Because as a lawyer, I think I should rather focus on the second and the third points. The second being the legal responsibility to deliver this climate funding to developing countries and to adapt to climate change impacts and ensure access to water to their citizens and to manage generally their water systems. And thirdly, the institutional part, the international bodies that are responsible of operationalizing these obligations. I will finally introduce some criticisms from academic literature, and I will pose a few questions that we may or may not discuss during the debate, up to you, and that I am addressing with my research. So, the problem and the thing that inspired my research and my passion on this very topic is the idea that the worst climate change impacts are to be suffered by developing countries, which happen to be those that have contributed the least to it. So I frame this in 3 differential dimensions. The fact that first, the largest impacts are to be suffered in developing countries, basically because they happen to be around the tropics, and for natural reasons, largest dramatical effects happen to be on those areas of the globe. Then the fact that they have contributed the least. So in absolute terms, it is estimated that by 1990, around 16% of the CO2 emissions that were emitted by these countries. And as from 1990, basically, they have increased maybe their emissions in absolute terms. But if you look at where these goods that are produced in developing countries are actually being consumed, you happen to discover that they are basically our factories. I'm talking as a Spaniard here, but basically for developed countries in general. So they are emitting more gases increasingly, basically because they have lower, or let's say broader regulations, environmental regulations, and they are emitting more gases, but they are eventually these gases are for producing goods that are consumed in the, as they say, global north. And finally, and most importantly, the fact that they have lesser capacity to add to these impacts and to mitigate their emissions. So basically, they have historically struggled a lot in order to have access to finance for the development plans and development policies. I'm talking about the issues that have been largely researched on the conditionality of the Bretton Woods and the fact that they were not to be trusted and so on and so forth. But briefly, basically, it is estimated by the World Bank and some agencies of the United Nations and also some other international organizations, like the OECD, that I was talking about just before, that estimate that somewhere around 250 to 274 billion US dollars per year will be necessary for developing countries in general to adjust to climate change. So this said, as it happens, access to water and water management and water governance in general is the let's say sector or the area that is to be affected or predicted to be affected the most by climate change. So the UN estimates that around 5 billion people, 5 billion is in Spanish 5,000 million people. So like we are nowadays around 7 billion, and that is like 3/4 of the population nowadays. Probably we will be more by 2050, but by 2050, 5 billion people could suffer water shortages. This has very large implications that I won't go through, but basically imagine the impacts on agriculture, on energy production, and the consequences of this. So the fact that developing countries are the least responsible for creating a problem that will nonetheless hit them the hardest whilst having the weakest capacity to confront the problem represents a reality that is receiving more and more attention in the international community. And as a consequence, there have been several institutions that have been created for the purpose of delivering climate finance to developing countries and assisting them with these issues. They are mainly surrounded this regulatory regime that is called the United Nations Framework Convention on Climate Change, UNFCCC, or UNFCCC. So this global regulatory regime basically contains the main principles, norms, rules, decision-making procedures, and also institutions. And I will look at them and briefly present them to you in order to reveal which are the legal obligations to deliver climate funding to developing countries, and which are the international bodies under this global regulatory regime that are operationalizing these obligations. So let's start with the legal obligations. So I'll briefly start with the main principle that works as the backbone of this whole thing of the obligation to deliver climate finance to developing countries, and then the two main treaties under the UNFCCC, the Constituent Treaty, the UNFCCC Convention, and the Paris Agreement. So the common but differentiated responsibilities and respective capabilities in light of different national circumstances, that's the whole name of the principle by law, is built upon the very well-known principle of sovereign equality that works as the vertebral column, the backbone of international law. The fact that formally all countries are equal. However, due to the colonial history and the differences in terms of development between countries, it is increasingly accepted a differential treatment in favor of developing countries. So in the context of climate change, climate action, this was materialized under this principle in Article 3.1 of the UNFCCC Convention, the constituent treaty of this global regime, and it was later extended in Article 2.2 of the Paris Agreement. Why extended? Well, I will come back to this, but basically, before it meant that all countries had common responsibilities to address climate change, but these responsibilities were differentiated in the light of their capabilities. And the Paris Agreement added also the circumstances. I will later highlight how this has influenced, in particular, climate finance. But basically, this means that there was a wide recognition of the fact that developed countries should take the lead in the joint climate action. This means that there are different obligations, and in the case of climate finance, developed countries have substantively stronger obligations according to their capabilities and circumstances as compared to those of developing countries. So, under the UNFCCC Convention, this constituent treaty that was adopted in 1992 and led to the global regulatory regime of the UNFCCC, Article 4.3 obliges Annex 2 countries to provide new and additional financial resources that are needed by developing countries to meet the agreed full incremental cost of implementing their measures on mitigation and adaptation, amongst many others, and that are agreed between a developing country party and the international entity or entities of the financial mechanism. So, Annex 2 countries, the countries that are obliged, relate to a list of countries. Okay, there is an annex to this convention that lists a number of countries. There are 23 named countries together with those that are part of the European Union. And these are obliged through a hard obligation through the wording shall that poses hard obligations according to international lawyers. Accordingly, on a partial reflection of the principle common but differentiated responsibilities and respective capabilities, not in the light of different national circumstances, that was not the principle at the time, only common but differentiated responsibilities and respective capabilities, the Convention explicitly differentiates obligations, posing a hard obligation to deliver climate finance on those countries that are listed in this Annex 2 list of countries, okay? Then, as I said, it talks about new and additional financial resources. Well, this is not defined in the convention. However, this is the result of a process of negotiation between developed and developing countries. Developing countries basically said, we don't want climate finance to be mixed up with the finance that you already provide to us as part of the official development assistance, ODA. We don't want that. We want a very specific channel, very specific way, let's say, or mechanism through which we are going to receive climate finance. And this is what new and additional means. So basically, there are some international bodies that I will describe later that are operationalizing this delivery of climate finance so that it is new and additional. Then the subject, developing countries, is assumed that refers to another list. This other list is called non-Annex 1 countries. And as for the quantities to be mobilized, well, this is very vague in my opinion, because basically said that these resources are those that are needed by developing countries in order to meet the full incremental cost. So this necessity is not defined. The need for it talks about the need for adequacy and predictability of the funds and the importance of appropriate burden sharing among developed countries. But this necessity, adequacy, predictability of the funds is not defined, nor the importance or the appropriateness of the burden sharing. As for the agreed incremental costs, these relate basically to the difference between a business as usual case scenario and that is a scenario in which there is climate change affecting. So basically imagine that you are talking about, or you are studying a project, a development project, the construction of some factory that uses renewable energy, and just because of this additional quantity that relates to the fact that you have to emit less gases, and that's why you are making it renewable. That's the additional, the full incremental cost that would be funded according to this article. So overall, under the UNFCCC Convention, there are hard obligations under the word shall posed on developed countries that are listed. We can know which very countries are obliged according to this list. But regardless of these, the obligations are rather broad and only bind parties to the procedural conduct of delivering funding. So countries are only obliged to deliver funding, but we don't know how much funding they should deliver. And it's rather a procedural conduct that is expected rather than a substantive obligation in terms of quantities. So over the next decades, there were several attempts to reach another legal agreement as the UNFCCC Convention. However, they were not very successful. You may have heard about the Kyoto Protocol that was successfully adopted in 1997. However, it has been argued that it was too restricted as to the countries bound by its norms, and many polluters such as China and India were not affected, were not bound by this treaty. The US therefore ratified it, Canada withdrew the agreement, and Japan, Russia, and New Zealand did not sign its extension. Also in Copenhagen, the COP15 in 2009 in Copenhagen, there was an attempt to adopt a legally binding agreement, but it did not succeed. Until 2015, the adoption of the Paris Agreement, and in its Article 9.1, it established a similar obligation to that one that I was just analyzing right now. It's a hard obligation also for developed countries to provide financial resources to assist developing countries. However, it introduced a few changes. First of all, the countries that are bound by this obligation are developed countries. It does not talk about annexes or lists of countries. It just talks about developed countries. So this is related to the extension of the common but differentiated responsibilities and respective capabilities principle, and the addition of the wording in light of different national circumstances. Why? Well, because since the adoption of the UNFCCC Convention until now, or until then, until 2015, countries just kept developing. And there was lots of tension regarding which countries should contribute, which countries should not, in the light of new circumstances. And in order to introduce this evolutionary dimension to this principle in particular, and to the whole climate action in general, basically it was agreed to refer to developed and developing countries. So basically, by doing so, the Paris Agreement extended the legally binding obligation to deliver climate funding from Annex 2 countries to developed countries in general. Also, it introduced a paragraph that says that other than developed countries are encouraged to deliver climate funding. And this is particularly relevant. Why? Well, because the whole system does not just rely on developed countries. Also, developing countries are encouraged to participate according to their circumstances and capabilities. So, finally, in relation to the quantities, it introduced a couple of principles. First, the highest possible ambition principle, and secondly, the the principle of progression, of informing the level of ambition of the country's efforts. These two principles basically promote differentiation through self-determination of the efforts pursued. But at the same time, each party commits to ambitious efforts. So basically, you say how much you contribute with, but you commit yourself to becoming more and more ambitious. The ambition and progression is reflective of the different responsibilities, capabilities, and circumstances according to the principle that I've been referring to during the presentation. So these are the obligations developed countries now, not annexed to countries, but developed countries in general are obliged, and the quantities must become more and more ambitious with time. So that said, let me now go into the international bodies that are operationalizing these obligations, that are basically taking the money from developed countries, or getting the money from developed countries rather than taking it, and putting into projects that address impacts, climate change impacts on water scarcity, on water governance in general. So there are basically 5 funds under the umbrella of the UNFCCC that are doing this. The first one is the Global Environment Facility Trust Fund. The second and the third ones are the Least Developed Countries Fund and the Special Climate Change Fund. The fourth one is the Adaptation Fund, and the final one is the Green Climate Fund. I will go fast through them, but please feel free to ask any questions that you may have during the discussion, because I would like to rather focus on the main criticisms of the funds and how they actually operate, rather than the characteristics of these funds. But again, just pose any questions that you may have during the discussion. In relation to the first fund, the GEF Trust Fund, it was the first fund created to operate the financial mechanism of the UNFCCC Convention. And it comes with a council. This council basically is the one that eventually approves the projects, the water scarcity adaptation projects of developing countries. It comes with a criteria that reviews the applications from developing countries, and and the trustee, and that is the World Bank, and that is basically keeping the money from developed countries. And then once a project is approved, it delivers the money to the implementation entities inside the developing country. I will explain better the process later, okay? But this is just highlighting the governance. It has mainly 3 institutions, or 3 rather organs, and in relation to water-related funded activities, it covers usually projects and programs addressing threats to freshwater systems and increasing availability of drinking water, irrigation of crops, and hydropower. So I will give you one example of a project that was recently approved by the Trust Fund on the water governance. It's called Environmental Protection and Sustainable Integrated Management of the Guarani Aquifer. It was a $13.4 billion project that was proposed by the Mercosur countries, Argentina, Brazil, Paraguay, and Uruguay, that elaborated an institutional framework for managing and preserving the Guarani Aquifer, which is basically one of the largest groundwater reservoirs in the world. As for the resource mobilization, it gets funding through replenishment meetings. These are basically negotiations that take place every 4 years among donor countries. Donor countries have meetings every 4 years and decide how much money they are going to give to the GEF Trust Fund and for what, more or less. The funding that has been delivered to this fund or has been pledged to this fund as of March of 2020 is almost $20 billion, and it has come from both developing and developed countries. The second and third funds, and I'll explain why I'm putting them together, but basically are the Least Developed Countries Fund and the Special Climate Change Fund, LDCF, SCCF. And these are managed by the same council, the LDCF/SCCF council. In practice, is actually the GEF council, the council that manages the GEF Trust Fund. The GEF also provides with the secretary services, and it has the same trustee, which is the World Bank. So basically, the GEF acts somehow as some sort of umbrella institution and manages three funds in the end: the GEF Trust Fund and the other funds. These two other funds, however, were for different reasons that you can ask if you want about, but were created afterwards, and they also fund water-related activities. For instance, one project on water governance is called Increasing Climate Resilience through an Integrated Water Resource Management Program in, forgive me if this is not the correct pronunciation, Ibandajo, Mahibado, and Gado Island. And they are basically three islands from the Maldives. Excuse my pronunciation of their names. But this project basically was approved in 2011, and is a project proposed by the Maldives together with this implementation entity, the UNDP, the United Nations Development Program. And it was they requested basically around $9 million to reduce barriers to climate adaptation in the water management sector and to ensure reliable and safe freshwater supply to Maldivian communities in these three islands that I just mentioned. The resources that are mobilized do not come from replenishment. Basically, they get funding from developed countries on a constant manner. And basically, they only get money from developed countries, not from developing countries, as the GEF Trust Fund does. So the next fund, the fourth fund under the umbrella of the UNFCCC, is the Adaptation Fund. And basically, this Adaptation Fund was created also in 2001 and is managed basically by also three institutions. However, it's more independent from the GEF as compared to the LDCF and SCCF. And basically, it has a board that is different from the LDCF, SCCF council, and is completely independent. However, its secretariat services are provided also by the GEF, and also has the World Bank as its trustee. It does not get the finance coming from replenishments like the previous two funds that I just described and assessed, but also on a voluntary basis, and only from developed countries. I got a rush to the last fund. The last fund is the Green Climate Fund, is the most important fund, or is expected to become the most important fund, at least because basically it has been created in order to escalate climate funding from the other funds and to accelerate the implementation of the UNFCCC Convention and the Paris Agreement. It comes with a completely independent governance system. It has its own board as the Adaptation Fund, but it also has its own secretariat that is based in Korea. It also funds water-related activities. So it actually has one specific area that is called water security and addresses water disruptions that result in health impacts. And by means of examples, the project Building Resilience in the Face of Climate Change within traditional rain-fed agricultural and pastoral systems in Sudan is a $25.6 million grant that was proposed by Sudan together with the UNDP again, and was approved only a couple of months ago in August of 2020. This project basically aims at supporting climate adaptation efforts among subsistence pastoralist communities in Sudan in order to increase the resilience of food production systems and improve access to water. As for the resource mobilization, it's pretty similar to the GEF Trust Fund, so it's also replenished. There are negotiations, donor countries meet and raise funding and decide how much funding is raised. However, this funding, as opposed to the GEF Trust Fund, also accepts money coming from developing countries. But mainly the main donors have been developed countries, being Japan, the UK, and Germany. So this is a more important. Oh, okay. Well, there is some problem with the slides. These were arrows, basically. No worries. I will explain to you how this works. This is a more important aspect of the delivery of climate finance, and is how it actually works. So we have seen these bodies, these institutions that are basically financial instruments that receive applications from developing countries and then approve them eventually and order the delivery of a particular amount of funding to a developing country for it to adapt to climate change impacts on water governance, and so on, so that then it can move on and offer water supply to its citizens, or just facilitate the aspects of governance that Rami was just talking about just before my presentation. So basically, this resource allocation system varies depending on the financial instrument. However, all share these basic aspects or features, let's say. They receive these applications that are actually made by developing countries together with a partner agency. Partners agencies are basically multilateral development banks or agencies of the United Nations, and so on and so forth, that must be partner of the fund that they want to get the money from, okay? So there are a specific number of partner agencies depending on the fund. Developing countries need to get in contact with these partner agencies, develop a project, apply to the fund. Then there is a cross of communication between the fund and the partner agency. So the secretariat of the fund will say, okay, you should improve this part of the project or this other, blah, blah, blah. They improve it, they change it, and gets back to the fund. If it is okay already, it moves forward. If not, it has to change it again. It usually takes from the fastest maybe to 5 years. So it takes quite some time. And eventually, when the proposal is good enough being respecting the eligibility criteria of the fund and the fiduciary responsibilities for the implementation of the project, then the council or the board of these instruments approves it and orders the trustee, which is the World Bank in all 5 cases, to deliver the money to the developing country through the partner agency, and then it starts the implementation. So this was a very fast and brief explanation of how climate finance works in relation to water governance. And I would have loved to go deeper into the details, because now it would be easier to present the criticisms. However, I will describe the main criticisms that I have clustered into 3 main groups, okay? The first one is the quantities that are mobilized. There are lots of critics that argue that this is just not enough. The money that is going to developing countries is not good enough in order to ensure access to water in developing countries. The second group of criticisms relates to decision making. And it regards, as I will explain, to, for instance, the length of approval, or issues related with the eligibility criteria, the countries that are receiving the largest amounts of funding, and so on. And the last, and the one that catches my attention the most, and is something that also Rama was referring to in her presentation, is the impacts on local stakeholders and in relation to their participation in these processes. So in relation to the quantities that are being mobilized, there are studies that argue, and this is difficult to estimate, okay, because there are many unofficial channels through which funding is going to developing countries, but it is estimated that around $681 billion are being delivered or were delivered in 2016 to developing countries. However, out of these, the OECD has estimated that only 71 billion came from developed to developing countries. So there were lots of money coming from being mobilized from different channels. But strictly speaking, in terms of the developed countries that we were talking about in the light of the Paris Agreement, only 71 billion has been mobilized. And out of these 71 billion, most of the funding came from the private sector. Only 10.7 billion US dollars have been allocated through climate funds to the climate funds that I just talked about. This basically means, remember that I was talking about new and additional climate funding, the funding that should be very specifically channeled through these very instruments, and that's what developing countries have been pushing for during the negotiations of these treaties. Well, so guess what? Out of these whole amounts of money, only 10.7 billion have been allocated through the climate funds. This means that a very small part of the total climate funding is being channeled in the way the obligations, the legal obligations, say should be being channeled. And in my opinion, as a consequence, sorry, there are like lots of critiques that you can see a few very interesting papers that you can have a look at. There are criticizing basically these quantities that are being mobilized. So let me tie this with something that I explained during the presentation, and is this very system of, okay, there are some legal obligations. I will rush now because I'm running out of time. There are these legal obligations that are hard. Do you remember the word shall? Developed countries shall deliver climate funding to. Well, so in spite of that, there are no very clear obligations in terms of quantities. They are rather procedural, and so these may be related to that. As a consequence, there are actually arguably 14 developed countries, according to the IMF, the World Bank, and the OECD. These are considered developed countries that have not provided climate funding through these channels, and these are Singapore, Bahamas, Bahrain, Barbados, Brunei Darussalam, Croatia, Equatorial Guinea, Israel, Kuwait, Oman, Qatar, Saudi Arabia, Trinidad and Tobago, and the United Arab Emirates. So I would like to raise this question that we can maybe talk about during the debate, and is whether there should be, or we should aim at adopting a legally binding commitment for developed countries, and specify the amounts that should be channeled. The second group of criticisms relate to decision making. You can see there a few of just a couple of articles that talk about different critiques related to the decision making with regard to the fairness of the funds, how fair they are in their decision making, how the funded activities are not sufficiently defined, so you cannot really know which activities should be funded or not. The length of approval, it takes too much time to approve and therefore to adapt to water scarcity in developing countries. And in relation to which countries are actually receiving most funding, we say that the ones that need the funding the most, the least developed countries, are receiving less than other developing countries. So the question that I would raise, and this is something that is being negotiated at the time of this presentation, is whether they will succeed at reforming these problems. Finally, the last of the critiques is that stakeholders such as private sector actors, civil society organizations, vulnerable groups, women and indigenous peoples from developing countries are suffering negative impacts from the funding decisions. So basically, there are authors that talk about some climate adaptation projects that have negatively affected to these countries, some also mitigation projects, and there is an increasing number of academies, especially political science academies, but also legal scholars, that are wondering whether the funds are sufficiently accountable to local communities. The tricky part of this, and I will just mention this, and we can talk about this during the discussion, because it's something that I look at during my PhD, is the fact that these bodies, these international financial instruments, are not states. Therefore, under public international law, under traditional approach to public international law, because there are some approaches that disagree with this, Insofar as public international law is traditionally focused on the states as the main actor, these should not be responsible or cannot be responsible for any consequence in their decision. However, they hold lots of power over these local stakeholders, these vulnerable communities. Therefore, how can we raise accountability, promote accountability of these non-state actors in relation to their decisions that affect local stakeholders? I propose a methodology that is called Global Administrative Law from NYU University, from the University of New York, that basically aims at promoting things like transparency, review mechanisms, participation, and reason giving of these decisions, and taking into account local stakeholders so that we can promote accountability. We can discuss about this later. But first, let me thank you for your time. Thanks a lot, and I really hope that you enjoyed this presentation and it inspired some doubts, questions, criticisms, anything that you may want.
Thank you very much, Professor Larrea. Sorry. Thank you very much for this clear presentation of not only the different funds, but on its water, the water management, but also for presenting us also these challenges, or as you said, these criticisms that probably are also challenges that all this system or this general system always built on the model of the United Nations, presents to us. So I think there are quite a lot of questions that I have. Probably not all are going to be discussed here. But okay, thank you so much. We are now starting with the debate. I don't know if we have any questions from the chat, from our audience. Para nuestra audiencia, perdón, simplemente les comento que los dos profesores, como he comentado al principio, entienden el español, obviamente. Si desean, pueden hacer su pregunta en castellano, si desean, la pueden hacer en inglés, en francés incluso, pero bueno, como ustedes quieran. Si prefieren, la pueden hacer por el chat o pueden hacerla directamente con su intervención. Si la desean hacer directamente en este tiempo de debate, así que les pido por favor que utilicen el icono que tienen en la parte inferior de su pantalla, que es una persona levantando el brazo. Entonces les daríamos paso y conecten la cámara si lo desean y pueden entonces ya presentar su cuestión. Tenemos una primera cuestión en el chat, de hecho del profesor Peñalver. Professor Peñalver says thank you very much for this presentation. He has a question for both speakers. Do you think that human rights, in special human rights to water or other environment resources, have any positive impact on water governance and on financial assistance to developing countries because of climate change? So the idea is, I mean, how can you relate, I understand, this the concept of human rights, or the human right to water, or the access to water, and the impact on water governance. And it also has some specific impact in those funds that have just been presented. So, which one of you wants to start? Professor, if you want to start.
Thank you, Professor Peñalver, for your question. Yes, I think that human rights dimensions can contribute on this enforcement and implementation of water governance. Why? Because there is a link, or there is a relationship between the right to a healthy environment and access to water. And this combination can reinforce the human rights, or can reinforce the politics to implement water governance. But I think also that the human rights approach sometimes come to complicate the approach of politics in water governance, because sometimes it is a little bit difficult to, for example, to make an implementation of OECD principles without, and in the same time, caring about human rights. For example, I take an example in Tanzania. OECD now is implementing the OECD Horizontal Women Program. OECD Horizontal Women Program with creating village assemblies or village water committees in some village in Tanzania. And the problem that some politics said, yes, we are going to make a defense for human rights and the right to women to participate on water governance. And on the other side, we have another groups who says, yes, this is a little bit complicated to implement because the society doesn't accept, because we have another thing to think about, for example, the lack of accountability, the lack of transparency in water governance, etc. So human rights, okay, it is something which make a push to water governance, but the problem also nowadays that politics sometimes when we want to make an effective application or an implementation for example, OECD principles, we have always problems with the volunteer or the political volunteer for this.
Professor Larrea, I don't know how this human rights dimension really is considered or not in those funds you presented.
The answer from the climate change regime viewpoint would be an absolute yes, but I think it goes in the lines of Rama's reply. I think there is so basically I think climate change legal scholarship agrees on the fact that there are problems in terms of enforceability from a human rights perspective. It's difficult to enforce human rights obligations. But just the fact that these narratives are becoming somehow more present in our minds, the right to water, the human right to water, and the right to a healthy environment, so on and so forth, from different NGOs, international organizations, and other kinds of actors, are basically spreading the word that there are certain things that should be preserved and should be valued. And I think this is definitely inspiring global decision makers in the climate change regime, but also other governments that are just putting more attention on respecting these rights. So I would say it changes the whole narratives. It pushes the decision makers towards addressing these issues. However, from a positivist viewpoint, as a positivist lawyer, I would say that the enforceability poses these very big problems. So therefore, I would never go through like a human rights regime in order to bring change.
Okay, thank you very much. Any other questions? Nacho Alvarez, please go ahead. Open your micro, or if you on your camera.
Okay.
Thank you.
Muchas gracias, profesor Larrea. Merci beaucoup. Una pregunta para la profesora. ¿Nos oye?
Es que te hemos oído cortado, ¿no? Me parece. Ahora sí.
Genial. Si se me corta, quito la cámara, que quizá hace que vaya el... Tengo una pregunta para la profesora Bontigú. Quería preguntarle, ¿cree que es posible implementar la gobernanza en aquellos países donde no existe el Estado de Derecho? De ser así, si considera que es posible, ¿cómo? ¿No se me oye?
¿Se nos ha cortado un poco? No, pero creo que... Adelante, adelante.
Si no quito la cámara, no sé si se ha entendido la pregunta, si no la repito. A ver.
Micro.
A ver.
I don't listen to any question.
No, yo tampoco. No está la profesora.
Perdón, tenía el micro apagado, perdón. Digo, la cuestión era principalmente, ¿no? ¿Hasta qué punto se pueden implementar estos principios en materia de gobernanza del agua en aquellos estados que calificamos y consideramos como estados en los que no se cumplen, ¿no?, los parámetros de lo que sería el Estado de Derecho?
Efectivamente. Muchas gracias, profesora.
Perfecto, perdón, es que estaba sin el micro. Rama, did you? I mean, the question was about how to implement principles that you had presented.
Yeah.
In those states that we consider states which are not complying with the rule of law.
Yeah, thank you for your question. I think that in reality it is a little bit difficult, or it is really difficult to implement OECD principle. Why? Because in my opinion, I think that in the politic of OECD, we have two groups of countries. We have the countries, third countries, which are not very developed, which have many problems, mainly economic problems, and sometimes problems of economic values. They have a lot of corruption, etc. And on the other hand, we have the developing countries that already benefit from the acquis communautaire or acquis European acquis on water, such as the Water Directive of the EU. So I think that in some countries of our EU member countries, it is not so difficult sometimes to implement OECD principles. With third countries, it is a little bit complicated because here we have not only water problems, but we have also human rights problems, we have economic problems. I take the example of Tunisia, for example, the implementation of OECD principles on water. Here we have problems of autonomy of the institutions, like, for example, Monnet or ONAS, the two names of the institutions, with a lack of institutional autonomy, the lack of transparency. So we have to face many local problems to implement the OECD principles. I know that for the EU member or some European countries, of course, we have environmental problems. Like, for example, in Spain, Spain has, I think, has robust environmental legislation, which adequately incorporate the requirements of the EU water acquis. However, in Spain, for example, and Professor Campins can correct me if it is not really correct, there are several gaps in policy implementation, including in the use of economic instruments and economic regulation to manage water quantity and quality risks, and coordination across sectors, agriculture, energy, environment, and levels of governments. We have also some other problems relating to budgetary constraints, administrative problems with sometimes with local authorities, etc. So I think that here we have to distinguish between two categories of countries who implement OECD principles. Third countries with their environmental, economic values, human rights, democratic problems, and EU countries, of course, with other problems, but here we have the facility with this EU Water Directive or the EU Water Acquis. I hope that this answer can help you a little bit to understand the difference.
Yes, thank you very much.
Nacho, no sé si querías añadir algo más, que había que levantar la mano.
No, he bajado, así que perfecto. Muchas gracias.
¿Alguna otra cuestión? I have two questions, one for each speaker, if I can. For Professor Bentigo, I would like to know, it's also about implementation, but from a different angle. I would like to know, what extent the implementation of these principles, how they really become efficient when they are translated at national level. You just mentioned now the case of countries that have all these different problems, or that political, economic, social, whatever. But I'm thinking in countries that, let's say, work more regular, more normal, that work well. But even in those countries, developed countries, I would have, well, at least I have the feeling that it's still to translate these principles to be implemented in specific tools in a national level as a domestic tools. And I also have a question for Professor Larrea. You mentioned when you were talking about the challenges or the criticism as one of your ideas, well, that it would be possible maybe, if I were understood, to consider some kind of binding obligation, binding action for developed states in terms of funding. So I was thinking, how do you feel, or what are your expectations, in particular for the climate, for the Green Climate Fund, in the next Conference of the Parties in Glasgow, the next Conference of the Parties on Climate Change and Meaning? Because actually so many issues were left open in the conference in Madrid. One of them, of course, being the financing. And also, of course, the cooperative mechanism and everything. I don't know how much, which are your expectations on the next Conference of the Parties? And then I also have another question for you. As we saw in your slides, all the structure, it's also, well, not dependent, but somehow related to the World Bank. Actually, one of the main criticisms also for the World Bank when funding these kind of projects is that most of them are usually mega projects. And this is also related to the, well, when you mentioned the impact on the local stakeholders. I don't know if you can just very briefly, because we are just on our time, just to say something about that. Thank you. Professor, whichever you want to.
Thank you, Mar, for yes. Thank you for your question. Yes, implementing those OEC principles, or how we can translate those principles in reality in some countries. I would say that in this point we need legislative and political leadership. We need legislative and political commitment. For example, participation of the public in decision making. It is a very good process, which is in the correct, which is in the correct way, in fact. And I think that some international instruments or convention can help here. I refer to Aarhus Convention concerning the public participation, which concern the environment, but also I think that can be politicals and legislators can inspire a little bit from this convention, Aarhus Convention, to apply it on water governance. Also, we have the judicial system. We need the certain autonomy of judges to apply some legislative texts, and to that the decision after that can be applied. I mean, of course, the organization, international organization or OECD, which try to do that, try to put the important keys of water governance, and after that, in the national level, it is case by case to apply those principles. But as I said, in European level, here, I mean, we have really many instruments that can help for implementation of principles. We have Aarhus Convention, we have a judicial system which is autonomous. We have also many norms and texts, legislative, concerning the participation of the public in decision making, etc. And I think in Spain we have really a robust environmental legislation in this point. Yes.
Thank you very much.
Okay, so in relation to the first question regarding the obligations, so for instance, I was hinting the fact that at some point during the negotiations, developing countries were asking for developed countries to provide for 2% of their GDP, like period. And so basically that's never going to happen, basically, because we saw one of the main reason actually why the Kyoto Protocol didn't succeed is because they were implementing top-down legally binding obligations and only on developed countries. Who are the countries that have to pay? That's always a big part of the discussion. As for the expectations of the COP in Glasgow, have no expectations against the backdrop of the global crisis. And this is unfortunately what happened in 2007. There was a big setback. That's why the legally binding attempt of Copenhagen in 2009 didn't work. We had this global crisis and people started to focus more on socioeconomic issues rather than environmental issues. So I think that I hope that we keep putting money for the environment because it's crucial, but I'm not so sure that decision makers will think the same. And in relation to the last question, that is a really interesting question because that is absolutely right, but it's just more beneficial for. So the question was in the lines of why does the World Bank, for instance, deal with projects that are larger rather than smaller? And it's basically because it's more efficient. Let's say you have to spend so much time and you have to pay so many people to implement a project. And if a large institution such as the World Bank does so for very small projects, that just is never going to work so well. So they have done, for instance, in the GEF Trust Fund, a program that is called SPG, a Small Grants Program, SGP, sorry. And it's basically small grants. It's a department that is very focused on the small grants that go directly to NGOs and so on. And this has proved to be a more efficient way, like dedicating a team to very small projects that actually reach the local stakeholders. And I think I really like that initiative. I hope that it's spread in other funds, climate funds.
Okay, so thank you very much. Well, I didn't know this last point. Thank you very much. So any other questions that you have, any other comments that you want to make? Well,
I have, if you permit, I have just a question for Gonzalo. Presentation was really so interesting, and my question concerns the hard law and the soft law in the field of climate change. You talked about the Convention of Paris and many other texts and international law, and I think that those texts are hard law, that states have some obligations to fulfill and to respect. And what about soft law in this field? What about soft law in the enforcement of climate change and the defense of water rights?
So, are you asking for obligations that are not included in the treaties that I mentioned, the UNFCCC Convention and the Paris Agreement, but yet that affect somehow to the implementation of the projects?
Yeah.
Okay. Yeah. So I would think right away about the so, for instance, the internal norms of the banks, or the criteria, the eligibility criteria, for instance, the replenishment negotiations. Do you remember that I said that in a couple of funds there are these negotiations taking place every 4 years, in which donor countries decide how much money they should give and to which kinds of projects. So basically, they are meeting in these reunions. Are very dark, very obscure. You don't really know what they talk about because there is no transparency. But in these reunions, they decide basically how much money is going where, and this actually has a bigger impact than basically a positive norm, for instance, because it's directly deciding which countries are going to succeed in their mitigation and adaptation policies and to what extent. So maybe that can be considered a sort of soft norm, let's say, right? These meetings or the eligibility criteria that they decide. So we will focus this time more in the next 4 years in Southeast Asia because whatever, and they start approving or mobilizing more funding toward those countries in that area. So that could maybe be another form of soft law.
Soft law, yeah.
Okay.
Thank you.
Okay, thank you very much. Well, I don't know. I think there is no. Oh, sorry. I see that. Let me see if I see. Okay, no, there is no more questions for you today. So thank you very much to our speakers this afternoon. I think that was a very, very interesting subject and a very interesting presentations. And thank you very much to our audience too. Muchísimas gracias a todos. Muchísimas gracias por atender, por asistir a nuestra sesión. Simplemente vamos ya a terminar aquí porque estamos 10 minutos por encima de nuestro tiempo. Simplemente recordarles que la próxima semana, el próximo martes, tenemos la tercera de las sesiones en una primera ponencia sobre la Directiva Marco de Aguas de la Unión Europea, que dará la profesora Nathalie Hervé-Fournereau, será también en inglés. Y luego tenemos también la presentación del profesor Peñalver sobre la participación pública del papel de las ONG en los conflictos relativos al agua. Me parece que será también una interesante sesión. Les recuerdo también que aquellos asistentes que son a su vez alumnos del título de experto en Derecho Ambiental de la Unión Europea deben presentar también un comentario, una valoración crítica de las cuestiones que se han tratado en las dos ponencias. Nada más, muchísimas gracias por estar hoy aquí y simplemente pues invitarlos a que asistan también a nuestra próxima sesión el próximo martes. And thank you very much to our two speakers today. Thank you for your presentations, for the interesting issues and challenge that you just bring to us. I think we have quite a lot of material to think about it. So, thank you very much for everything.
Thank you.
Gracias a todos.
Muchas gracias.
Gracias a vosotros. Ahora dejo de